Start. The Honorable Supreme Court, in the judgment passed in the matter of P. Vijayan versus State of Kerala and others, 2010 in bracket 2 SCC 1398 2010 in bracket 1 ACR 879 in bracket SC, held that para 10 dot. Before considering the merits of the claim of both the parties, it is useful to refer section 227 of the Code of Criminal Procedure, 1973, which read as under para 227 dot discharge if, upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for not proceeding against the accused, he shall discharge the accused and record his reasons for so doing, Para, if two views are possible and one of them gives rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage, he is not to see whether the trial will end in conviction or acquittal, Further, the words not sufficient ground for proceeding against the accused clearly show that the judge is not a mere post office to frame the charge at the behest of the prosecution, but has to exercise his judicial mind to the facts of the case in order to determine whether a case for trial has been made out by the prosecution, In assessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into a weighing and balancing of evidence and probabilities, which is really the function of the court, after the trial starts, 11 dot. At that stage of section 227, the judge has merely to sift the evidence in order to find out whether or not there is sufficient ground for proceeding against the accused, In other words, the sufficiency of ground would take within its fold the nature of the evidence recorded by the police or the documents produced before the court, which ex facie disclose that there are suspicious circumstances against the accused so as to frame a charge against him, Para 12 dot. The scope of section 227 of the code was considered by this court in the case of State of Bihar versus Ramesh Singh, wherein this court observed as follows, para 4 dot, strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial, But at the initial stage, if there is a strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused, The presumption of the guilt of the accused, which is to be drawn at the initial stage, is not in the sense of the law governing the trial of criminal cases in France, where the accused is presumed to be guilty unless the contrary is proved, But it is only for the purpose of deciding prima facie whether the court should proceed with the trial or not, if the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offence, then there will be no sufficient ground for proceeding with the trial, full stop, over.